Yes, sir.
We want read appeal of 2024 to come under fresh admission.
Admission. Since 24, it has not been posted.
No, admission, why they have mentioned it?
Post, we have made it automatic now. To give that, it will be posted any day, someone, preferably next week or week after next.
Where the rate appeal is 2024.
Yes. Yes, Mr. Bose.
Please mention fresh admission.
45.
In your memo also, please mention fresh admission because they understand what is fresh, what is after notice. They can't locate it. So always write it fresh admission.
12 to 11
One second,
to
only
13.
one person.
Yes.
45.
Well, I will read. Your lordship is correct.
Nobody. You are the only person who is seeking time now.
No,
you
I'm
are
not
also.
seeking time.
Okay.
Well, let it take this, but I am writing. 12 to 11 to 13, 12 3, 14 to.
No one is there in the BC also. Straight away come to Mr. Bose.
Well, the item number 45.
You are the instructing counsel.
No, you know, I do have a separate one.
You are separate.
Earlier, you know. So you tell your number. 42, 43 euros. But 41, 42 euros can be posted to 24. Similar matter is
24. On 24, they have posted. And call this 41. 41 and
42 euros.
41, 42.
And 43, in fact, your lordship has become infructuous because the notification file a memo in the memo. So they have included now.
Yes. That we have done.
So include everyone and every
institution. Our petition was second G should be there, and we have conducted this second.
You have considered to the prayer.
Yes. Yes, ma'am.
Can we write that way? Learned counsel appearing for the petitioner has filed a memo dated 17/7/2025, which reads as under. Afterwards, sick, because English is not there. Next paragraph. In terms of the memo, leave having been accorded, writ petition is disposed of as having become infructuous. First, cost matrix. Annexed with the
advertisement dated 5/7/2025. Should we give this?
This one, cost matrix.
Maybe pardon, Lordship. Item number 37.
37.
My Lord. I am for the applicant. My learning is there for the respondent number 1, Lordship. They play for 28. It was heard.
28. Why specific date?
No, it was heard.
It was heard. Matter was heard.
Whether the writ appeal lies against the civil court decree or not.
The election
case, whether the writ appeal lies after coming from the appellate.
Yes.
But nothing remains for to be further heard actually. We should have closed that actually.
Yes.
You wanted to do some research from your side, na?
No.
No appeal lies against that. No intra-court appeal.
No intra-court appeal. In view of the Rajasthan judgment.
Correct.
Yes.
There are many judgments. Ridge Hotel versus so and so.
Yes.
Tangabalu versus State of Tamil Nadu. Several judgments.
No, wait.
And I
went through Radhesam versus Chavilan.
Pradesh.
You should. The youngster, then
I went through 5 judgments, your lordship gave that.
Share those copies.
I have given.
The sister wants some
Yes,
time.
I can give.
Youngsters should read. Reading is very important. It helps you. It widens your horizon. It helps you in having family relationship, body relationship. So many things will happen. So Bible says knowledge is power. Understood? Be knowledgeable. Got the point? At least 2 hours, 3 hours you should read. Minimum 3 hours you should dedicate for reading early in the morning. That gets imprinted in your mind. Then respect begins. Only knowledgeable people are respected. Bharata. Bha means knowledge. This is land of knowledge. Got the point? Next time you have to argue. Call this matter on so and so at the request of Sister Service.
No, let it be the first week of, second week of August.
Second week of August. Second week of some date. You can. 13th August.
13th.
Yeah.
I was mentioning a item number 45.
45.
Yes. But here, the wife is the appellant against the judgment of the decree passed on divorce filed by the husband.
Divorce is granted.
Granted. But nobody questions the divorce. Only alimony. And I have filed, I am not getting a single rupee from the husband. I filed an interim application because I tried my level best to get the income source from the of the husband. RTI information was refused by the KT University. I have filed that IL. If your lordship may kindly accommodate as last case before rising.
You mentioned it just when you want this matter to be posted on some other day.
No, my lord, I'm
Today itself.
if your lordship may
Because of publication.
Yes.
You want that information to be extracted from the university.
University.
You inform Mr. Patnaik.
Yes, I will inform
You bring your friend on.
Yes, as last case.
If he agrees that he will get his salary certificate from his employer, I mean the husband's employer, then let's solve the problem.
So we need not direct.
Last case before rising, if you not should I will inform.
At 2 p.m., just take a chat.
Come at 2. Let us see.
Item 1.
Item 2, the appellant wife.
Yes.
Matter fixed.
Item 2.
You are in.
This is upon provided for organization.
Item 2.
This appeal of the deed.
That is the
either representative of the appellant organization or the council.
Well, I appear on behalf of opposite party number 1, the official liquidator, on behalf of
Mr. Dr. Churi has taken notice on behalf of PPF organization. And today there is a resolution. So, Union of India is a party. You are appearing.
official liquidator, Millets.
Oh,
The official liquidator, OP number 1.
That the company is in liquidation now.
Millets, I have been assigned today, Millets. I have not been able to. I have been assigned the brief today itself.
looks like Western Orissa Sugar, no more is there.
No, it's ordered to be wound up. All right. Call this matter next week. We'll see them. Call this matter next week to enable advocates for the appellant to come and argue.
Item 4.
4. Yes, sister was here.
My lord, in item 4, you
It's not possible today with one day.
If it is possible, we'll have. Otherwise, we'll give some day. Sister has left the protocol, perhaps. Yes.
my lord, item 4, your lordship. This is the writ appeal challenging the judgment of Honorable Single Judge, your lordship, by the private parties.
Private party.
OPSC has filed a writ appeal 2542 by 2024. 2542 by 2024.
2542.
My lord.
Of 25.
24, my lord. 2542 by 2024.
Along with the writ appeal number 2542 of 2024, week after which.
Also check where State Bank might have filed also.
My lord, I'll check. But OPSC writ appeal, I have received the copy.
All of you. Selection by OPSC, so recommendation by requisition by state. So, check it.
The post of assistant professor under the PWD category. the 4% is being reserved. So that calculation, though it has been directly by the honorable single judge, but considers against that order they came up in the private. But other parties are also been added as respondents.
Item 5.
May I please, Lordship?
Yes, sir.
This is a writ appeal challenging the order dated 25/6/2024 passed by the Honorable Single Judge. That is, my writ petition is dismissed, holding that the property is equally having mortgage in other loan. There is fact remain that I had taken 2 loans.
One preliminary issue we may have to answer, Mr. Das. Writ appeal is maintainable against this order. The writ court, single judge court, was exercising jurisdiction 227.
226, my lord.
No, you have written that.
My lord.
You have written 226 in your petition. But
Right.
order fits into 227. Whether an order is passed under 226 or 227 does not depend upon which section,
by
which
mere right.
provision you have quoted in the petition.
Absolutely
In your
correct.
petition.
Here, my lord, I have challenged the inaction of the bank of the PH.
Election is 226.
It's not against any civil court order.
Translated, then it becomes 226. Inaction of the bank.
Bank.
In
By not giving me NOC and discharging my charge against the
dispute, you have given money. You have paid back the money.
despite
With the mortgage.
my lord,
Who appears for the respondent?
notice has not now.
To issue a merchant notice. There is one judgment of Karnataka High Court on that. Just look into it, bring
Right.
that in your favor. Issue a merchant notice. Returnable within 2 weeks. 2 weeks. Requisites within 4 working days. Covered by judgment, no? No.
Item 6.
Yes.
May I please, your lordship?
Yes. Letters connected matters are posted on which day?
24th. Let's
Show notice.
Miller,
Need,
in course of the day, I will serve the copy on my lord.
that part.
Can I pardon, my lord?
First, Mr. Mohanty and Mr. Mohanty, learned AG is requested to, on request, accepts notice for the first respondent.
1 and 4 Miller.
1 and 4.
Miller. Director of Nursing.
1 and 4, you are right. Learned panel counsel, Shri, appears for response numbers 2 and 3. Yes, sir. 2 and 3. First off. We are told at the bar that connected matters are posted on 24/7. First off. Call this matter also along with them on that day.
Miller, may I just permitted to bring to your lordship kind notice dealing with an identical matter in the last occasion, the sole question which is involved in this case, filing of the fire safety certificate. We have filed it. That is our case, Miller.
And then-
Your lordship specifically directed my learned friend appearing by the state council, state government, Miller, to obtain instruction whether it is genuine or not on that occasion. Your lordship can reflect it only. Because we have not made the fire officer as a party in this case, we have filed it, Miller.
On the next date of hearing,
Miller.
the respondents shall make submission as to the authenticity of
Right.
the fire certificate in question.
Right.
Come on.
Filed by the petitioner.
After making all reasonable inquiries in that regard.
Matter. Oh, lordship.
So that matter will be over.
Matter will be over if your lordship
At least we will know the battle lines. Battle lines will be.
No, my lord, last year,
If your lordship
allow
will-
the fire certificates which were given later on, before the admission, we have allowed those cases. This time also I have suggested them. These matters which are coming, if this certificate is right,
Yeah,
we should allow them.
state.
Yes,
Next one.
Then your lordship may kindly also be pleased to fix up this matter for admission stage. It can be disposed of. On that date, several cases are there. Your lordship may kindly.
We said along with that matter. What is the stage of those matters? We don't know. That's the reason. Yes.
Item 8. Item 8 also, I am appearing on behalf of the petitioner institution. It is the engineering college matter, Miller, in which AICT has granted approval like the yesterday case. My learned friend, Mr. Satpathy, is appearing on behalf of the BPUT Miller. He made a request on yesterday Miller to come this matter, the yesterday matter, that is WPC number 19441 of 2025.
Your Lordship has
Fix up
the
this
matter
matter.
on 22nd.
Correct.
So
But notice needs to be issued to you.
Yes, Miller.
Yes. Here your Lordship has already issued. I have already
Yes, appearance.
Yes, Lord. On
Okay.
16th.
We'll have this matter on which date?
22nd.
Madam, my lord.
20 seconds.
Madam,
Along with similar matter.
Miller, at the stage of admission, that was your lordship order. In the last-
That matter we.
No, this order. Your lordship may kindly appreciate the last order.
Worry, sir.
Anyway, mention also, we'll take up that matter. Don't worry.
I am
We'll
for
take
the
up that
OJ
matter,
matter.
even otherwise also.
I am for the
We understand that because the timelines are there.
I am for the OJ matter. I am for the OJ. Amita Mishra.
Sorry.
On behalf of Mr. Shripad.
For the
On behalf of Mr. Shripad. OJ for
Joint entrance.
joint
Odisha Joint
examination committee.
the second round registration for second OJE will start from 24th.
We have put it on.
So, Madam Mensa, that we have suggested Mr. Satpathy is there. Serve a copy in order to avoid the delay.
Correct. That's the reason on 22nd. Be ready on 22nd.
Yes, yes, kindly one line because I have filed by Baklata. My name is not reflected. So your Lordship, please just
Register to print the name of Sri Satpathy, learned panel counsel appearing for
OP number 4.
OP number 4.
Much obliged.
Yes, sir.
On the head of admission, lordship may kindly, that is the order.
Yeah.
Your Lordship, item 9, may I plead, Your Lordship?
You are appearing. What is this matter about?
Your Lordship, here I have prayed for renewal of my institution BSc nursing course, 15 number of seat, Your Lordship.
You are the institution.
Yes, Your Lordship.
Huh.
Your Lordship, here what has happened, Your Lordship? Admittedly, there was an advertisement issued by the opposite party DMT, Your Lordship. And with a wrong notion, Your Lordship, if you'll see my annexure at page 11, Your Lordship, annexure 1. Your Lordship, in that order, Your Lordship, I was granted BSc nursing course and I was supposed to renew my BSc nursing course in the year 2027-28 academic session, Your Lordship. Your Lordship, admittedly, I was in a wrong notion. I was in a wrong notion.
Extra Haveli is added to wrong. That's become wrong.
Okay.
Your Lordship, 50 number of seat was supposed to be renewal this current academic year, Your Lordship.
My lord, I have got to take out the instruction over telephone. 9 numbers of institutions.
No, to file pleadings. Can we act upon your telephonic conversation?
No, my lord. No, my lord. What I am submitting, so let it come next week. I'll get the
Notice was ordered already.
No. Last time it is.
Issue notice. State is also party.
Yes, my lord.
Sri Mohanty, learned AGA, on our request accepts notice for response number 1. Learned panel counsel, Sri appears for response numbers
2 and 3.
2 and 3.
I am available for open for my lord.
Sri Satpathy appears for OP number
Satpathy
So,
Amit Kumar
5.
Amit Kumar sir.
with your senior or
Alimut DSG, man.
Which your name then?
so Amit saw CGC.
My lord.
CGC along with DSGI. For OP 4.
Directed copy.
Follow.
Copy me.
Please give copies.
Yes, Your Lordship.
Share copies.
Yes,
Next week it will come, my lord. Next week.
Yes, next week on which date? Next week, which date will be convenient to you? On education matters, we'll have same day, 24th.
Yes,
Oblige, Your Lordship.
That is your instruction.
No, my lord, my instruction is that those 9 institutions, we are allowing them to deposit the fees for this renewal, and we will consider them because there was a mistake from our side. We should have given the instruction to them because we have given them recognition already. Okay. For those 30 seats in the previous they were having.
This liberty may be granted.
You are more than clear at least.
Yes.
You are saying that on 24.
Yes, man.
You do
I will get
something.
it.
You keep your, because it's timelines are there.
No, man, I will get it.
Can he deposit without prejudice? He's requesting that.
No. They can. Because that is my...
No, suppose you keep that money, don't return them.
No.
Yes, sir.
My lord, I have given one case.
That's why you use it.
Yes, sir, Lordship.
Without prejudice, as it is suggested that by the Lord Counsel for the petitioner institution that they will deposit what fees, sir?
Requisite fees for renewal. Renewal fees.
The requisite fees for renewal of NOC to be issued by the OP3.
Yes.
First off.
Liberty is granted for making the deposit as stated.
Yes. Yes.
Obligations.
Item 10.
Notice has to go.
Already notice has gone. In pursuant to the order dated 25/6/2025. But so far,
You have to await service.
return has not been awaiting the.
Await
You
service.
can contact the police.
I will contact the concerned police.
Await.
Already notice has gone and.
All right. Await service of notice on the respondent accused. Yes.
Item 11. 11 is same.
11 has appeared. 11
Has
has
appeared.
appeared. So today let it be adjourned because he is not there, but not also on VC.
Call after 2 weeks. Call after 2 weeks in view of Band call. Okay.
Item 12.
Also said
Number 10.
12, sir.
12. No, 12. In order to be passed as in 10.
Ajin number 10.
Await notice.
Ajin number.
Item 13.
So saw. He has left. Arjun.
Yes. Call after 3 weeks.
Item 14.
State appeal millers, 104 days delay.
Item 14.
14 millers, state appeal millers, millers 104 days delay in this case millers. Here is a on 21/1/2011 advertisement for the engagement of Shiksha Sahayak millers issued, and the respondents have made an application under the PS category millers.
PH category.
PS category showing that more than 40% disability millers. Thereafter, they have engaged as a Shiksha Sahayak, and after completion of the 3 years miller, they have promoted to junior teachers. One Vasudev Sahoo miller filed a writ petition challenging the selections. In that writ petition, this
Selection or appointment?
Appointment of the petitioner as well as selection of petitioners.
Okay.
Is category. On this honorable court on 5/5/2015 directed to conduct an inquiry by the Superintendent of Police Vigilance. And
Then the allegation is they do not fit into PH category.
Not is a false certificate, and they have not disability as shown in the certificates. And investigation was conducted, and thereafter high power exemption board was constituted by SCB Medical College and referred those candidates to that medical, and medical board so that they have less than 20% disability.
So it is no disability at all.
No disability as well as per the Act millers. Thereafter Miller and so that this respondent
ocular disability or physical disability?
Vision.
Ocular disability. So that should be how much? Minimum should be 40.
40%.
To claim this benefit.
As per the Act 2R of the Right to Disability Act. And that respondent of one CC point that shows that report shows that is not genuine certificate.
The original certificate is not genuine.
Not genuine. That report shows that.
Not genuine means whether certificate is
Not issued,
or it is fabricated document.
not issued and not found place in, not issued, not found place in the register of the issuing authority.
Authority.
That is the finding of the report. On basis of that, we have dismissed that.
Stamp and signature.
No, even they will forge fabricators will do everything.
Report shows that. On basis of that, we have disconnected.
Whether notice was issued to them in the inquiry.
No. No, they have appeared in the medical board.
Before the medical board, they appeared.
Yes,
Even they were directed to undergo the test also.
Yes.
What is it?
Your Lordship, may kindly see page 23 for a moment.
But requires consideration.
No, I'll show you. Because the SC Medical Board has stated that the certificates are genuine. I'll show page 23, Your Lordship.
Certificates are genuine.
Yes.
No, SCB did not issue.
No, they verified. They verified. Your Lordship, may kindly see page 20.
We'll understand the things first.
Exactly.
Comment.
A certificate can be fabricated even when its contents are true and correct. That's what Lord Atkins said. Is it? Suppose if somebody certifies that I am Justice Krishna DIXIT, it may be a forged certificate, but contents may be true. So question is it a fabricated? You may be suffering from ocular disability of the description. 40%, yes, we agree. Question is whether the certificate is genuine or not.
Page 23 will clear that, Your Lordship.
Mr. Rautre,
My Lord.
why you are asking another authority to issue the...
No. We have the subject.
The certificate is issued by which authority?
CDMO.
Say whether we
CDMO.
My Lord.
So simply CDMO, it's not, CDMO is an independent authority, no relationship with any medical college.
My Lord.
So you don't bring in medical college there.
No. Your Lordship.
So CDMO, what the CDMO has
The
said.
background is...
Kindly just let me
My Lord.
listen. Because
Hear us. You need not listen.
And more concern is that weakens your case. CDMO, the allegation is that CDMO has issued the certificate or you produce. CDMO is not asked, or the persons who have signed ENT specialist.
No, they only have produced those certificates.
So they have to say that yes, we have issued it. You have heard the AGA, he said that it is never issued by those authority.
No, that is a finding. Your Lordship, page 44.
Yes, only page 23 for a moment, Your Lordship, may kindly see.
Suppose now this court declares.
That is the report.
Suppose now this court declares that those certificates are genuine. Is it possible?
No, that has already been declared by the Appellate Medical Board, Your Lordship. That is why I'm saying.
Appellate Medical Board, please don't miss the sequence. Appellate Medical Board is a different board, different certificate, different set of people. You are perhaps meaning to say that Appellate Medical Board has also given a report. We are not there.
You are not on that. It may be true. But we are on your conduct in producing a fabricated certificate.
That is not, Your Lordship. The advertisement was issued in the year 2011 in respect of 257.
To which page?
Page 44.
Page 44. During inquiry, Your Lordship, see that.
No, he wanted us to read
page 23. Page 23 for a moment, Your Lordship. I'm page 22, last 4 lines. Page 22,
again subjected to medical checkup.
Page 22, para 6, last 4 lines. Page 22, true, of the appeal.
Petition number 1
produce a disability certificate under Rule 4.2 of the Persons with Disability Equal Opportunity Protection of Rights and Full Participant Act 95, read with the guidance of the Ministry of Welfare, Government of India, dated 6/8/1986. The disability is said to be visual, temporary, and to the extent of 40%. The petition number 2 was issued with a similar disability certificate for visual disablement with 42% disability, which is likely to...
There is 45%.
45. And Your Lordship, the vigilance report is quoted at page 23. The serial number, the result of the verification, last column, result of verification about genuineness of the disability certificate. So far, petition number 1, Sisir Kumar Sahoo, not genuine as not mentioned in the issue register of CDMO.
Number 117.
17, yes. That is petition number 1.
190.
My Lord?
117 and 190 are the mentioned as number of certificate.
Yes. Now this one, then petition number 2 appears genuine. Register of Honorable CDMO office is to be verified. Petition number 3, Sulagna Kora, not genuine as more than 5 years old. The petitioners were again subjected to medical checkups in SCV Medical College and Hospital, Cuttack. The following findings were given. Page 24.
1 second. Come to The third candidate,
Yes, Your Lordship.
not genuine as more than 5 years, means what?
Means she has
Validity has expired.
no. The certificate was issued in 2009.
The moot question will be, did you produce these certificates?
Yes.
Answer is
Yes.
Whether these certificates were issued by the authority who purports to have been issued them.
The certificate was, so far as the Lordship asked about petition number 3, Silogna Karo, not genuine as more than 5 years old. The certificate was issued in 2009. The advertisement was held in the year 2011. But the vigilance inquiry was conducted in the year 2015. In the year 2015, the certificate was 5 years, more than 5 years old. But at the time of engagement, the disability was temporary, was issued by CDM in the year 2009.
Whether temporary disability people are also entitled to.
Yes, Your Lordship.
There is no mention about temporary. Your Lordship, see that certificate.
Right? No, if these certificates are fabricated, even if their contents, we are repeating again, even if their contents are true, you are liable to be ousted because of the content.
My Lord.
The authority who issued the certificate said, we have not issued these certificates.
No, they are saying that the not genuine as not mentioned in the issue register of CDMO. Then it was verified by SCB Medical. Your Lordship, may kindly see page 24. But 3 of the letters are genuine, Your Lordship. May kindly see page 24. Page 23, last para, the petitioners were again subjected to medical checkups. My Lord.
Instead of quoting the judgment, you straight away go to the report. Because
what the report said, inquiry report said.
My Lord.
That page 44.
That is
44. So that you analyze.
Page 42, Your Lordship.
42.
No, 42 is not the concluding quote.
Page 42.
Finding is
Page 42.
Finding is 44.
Your Lordship, may kindly see page 42 for a moment.
We will see that page also. Yeah, what is that?
Page 41. So the disability certificates issued by the different departments of SCB Medical College and Hospital Cuttack in favor of the following 19 PH candidates were verified by placing requisition and obtaining repair.
Where are you reading?
Reading actually.
Page 41 last.
1 second. Slowly you have to write. There should be a pause between 2 sentences.
You have missed 40. 40. Go to 40. In course of inquiry.
In course of inquiry, verification was concentrated to 22 PH candidates selected in the final merit list of Sikha candidates prepared by the DPC SSA Denkanal disability certificate issued by the CDM and Denkanal in respect of the following 22 PH candidates of the final merit list were verified. On receipt of the reply from Superintendent SCB Medical College Cuttack containing the opinion replies from Professor and HOD with prescription notes. ENT along with prescription and reports, opinion of Professor and HOD of orthopedics and opinion of HOD of ophthalmology and Chief of State Referral Eye Hospital. All course and registers were verified and scrutinized. The following table shows the result of the scrutiny and the verification of the same.
Who are your clients here?
Your Lordship, 17.
5. Jasmine Behra?
Yes, one is serial number 17. Sisir Kumar Sahu, not genuine as not mentioned in the issue register of CDMO. Jasmine Behra is serial number
5.
That is appears genuine. Register of Honorable CDMO office is to be verified. And 21 is Sulachana Koro, not genuine as more than 5 years old. This is the report of the Vigilance Department. Then, so also disability certificates issued by different departments.
So come to 40. Suchi Lagna is a respondent here.
My Lord.
721. Then in that serial number, the next page, who are the
serial number 11?
Well,
letter genuine. Sisir Kumar Sahu, letter genuine. Suchi Lagna Koro, letter genuine.
Sir, while we are reading, you are just jumping.
Page 42, the table.
Number 4.
That is regarding from SCB.
My Lord.
So that was not considered by the selection committee. So look at the top of the table. That
yes,
is missing it.
Yes, Lordship. So page 41 starts. So also disability certificates issued by different departments of SCB Medical College and Hospital in favor of the following 19 PH candidates were verified by placing requisition and obtaining reply along with the copies of the disability certificates of each person. Although notice letter.
They are in the third column or the fourth column.
My lord.
Find out this handicap percentage.
Yes, your lordship.
So that you place.
That is, yes, serial number.
You are not placing it.
Serial number 12. Sisir Kumar Sahoo, letter genuine, less than 20%.
Sir, you are missing the third column. Visually impaired, 40%.
My lord.
So that should be your argument.
Category of person as per the CDMO is 40% after verification
So
of the
less
SCB.
than 20%. So,
My lord.
so that you can place it that for post consideration what was there and what.
My lord.
So that way you place it. Sisir Kumar
Sahoo.
respondent here.
Yes, no one. Respondent 1, that is 40%. Then the next column is.
When they say letter genuine, suppose somebody may question that SCB Medical College examination also is forged. So at least to that extent, they show that it is done and it is the correct letter from the
CDMO.
Re-reference to the not CDMO.
No.
Again, you have missed it.
The result of verification, your lordship may kindly see last para.
You are not reading it, and lordship may kindly see.
No, page 5.
Fourth column, top. Look at top.
Result
CDMO repeatedly.
Result of verification about genuineness of PH certificate received from SCB.
SCB, not CDMO. But you are again and again saying
received from
CDMO is third column.
CDMO I am referring because in respect of petition number 1.
CDMO is 45%, SCB is 20%.
My lord.
So that you have to place it.
Yes, your lordship. And the three of the petition.
Sri Ramchandra Medical College. It's a referral hospital here. Up to Department of
And another is
Chief District Medical Officer.
He says 45.
He is the district level. Now CDML.
Now, what is the procedure for getting assessment of ocular disability?
Medical board.
Medical board. Yes. In this, it has happened.
Yes.
Yes.
It has happened. They said that
because in the year 2011, when I submitted my certificate, that was temporary in nature disability. When the reassessment was done as per the direction of the Honorable Court and the Vigilance Department did the inquiry, then in the year 2015, it has been reduced to less than 20%. Which the Honorable...
But as on the date you were selected, you
2011.
made the application.
My lord.
You made the application in 2011.
My lord.
Selection took place when?
2011, appointment in 2011.
Whether a temporary ocular disability is recognized by law as a ground?
No, it's a permanent, I think.
You show that. Not question of thinking what the rule will say. That also will not.
That is page 28, your lordship.
Because genuine certificates. There is no.
There is reservation, your lordship, see the reservation.
There is not a case of fabrication.
Lordship, see that 34. That is reservation.
Extent of disability. Which rule?
Rule 34 of the Miller's Right of Persons with Disability Act 2016.
Correct. Does it speak of temporary disability or permanent? What is meant by temporary disability in ophthalmology?
Only one.
Every disability goes on progressively increasing unless halted. Yes. That's what standard books on ophthalmology will say.
Either it should be changed time to time.
Only time to time. It is variable. Is it not? Generally progressive.
Yes.
But he is saying, as on the date the selection took place,
yes,
I had this disability. And where is the case for you? And case of fabrication is not true. Maybe there are lapses this side, that side.
No, that is the inquiry Miller's, that is page 44 of that category stated that certificate has not been issued by the...
No, just one sentence will not do.
Lordship,
you have to read the whole report and then come to conclusion.
Read it slowly, 44, during inquiry.
During inquiry, it was established that the certificate shown to have been issued by CDM Dhenkanala and produced by the candidate Monnaledi Tripathi and CC Kumar Sahoo, present respondent, have actually not been issued from the office of CDMO as it is not mentioned in the issue register.
Question is, they did not mention in the issuing register. That is, absence of their entering it will not render them fabricated.
So is it your case that serial number 190 and 170 in the issue register,
They were
issued to whom?
That is not mentioned. That is not mentioned in the report.
That does not appear to be fabricated. Maybe that the officer who should have written it in his register has not done his job. If he has not done his job, no, we can't, because there seems to be even otherwise also. Suppose a sale deed is registered.
Yes.
But in the column which is that your form, I do not know. In Karnataka, we have form 16. Suppose in the form 16 register, if they do not enter, sale deed does not become invalid. Normatively, he should have made entries that somebody presented the sale deed and the execution is admitted. Therefore, we have registered it at document number so and so of the year so and so. This minimum had should be reflected in that particular register. I do not know what the nomenclature of that register is in your state because it varies from state to state. But here,
the case Miller's not issued and not mentioned in the register.
No, not issued because it is not mentioned in the register. That's your case. There is a slight difference between these two. And already how many years you have been working?
2000 since 2011.
2005. And subsequently, they were subjected to medical examination also. And reports were also not that doubtful. Since last
it's a person to direction of this honorable court, inquiry was conducted.
Inquiry was conducted.
Yes.
The reasoning, how we have to read the report. Report is prepared under section 45 of the Evidence Act.
Right.
Is it not?
Right.
To assess what the report is saying, whole report has to be seen by us. Report is not the gospel truth. It is expert evidence.
Piecemeal basis, entire report should be.
Right. There are some observations and the reasoning. This is not genuine certificate because it is not entered in our register. You should have asked person who has signed, was he there in job?
Whether genuine or not.
You should have confronted that certificate. Mr. Doctor, did you issue this certificate? Because this we are asking you, because it contains your signature. Is it your signature?
And there is no finding in that respect, no finding.
There is nothing, but how can we indicate those people on the basis of half-baked the reports? We cannot do that. Already they are in job now. You will be putting the salt.
They were disengaged, then passed on to the
direction you are reinstated.
Contempt, the subject to writ appeal, we have been reinstated.
Nothing. State is in appeal against the order of the learned single judge dated so and so in WP number so and so, whereby relief has been accorded to the respondents in as much as the certificate ocular stroke vision certificate was held to be
Vision impairment.
Vision impairment certificate were have been held to be genuine. First, next paragraph. Learned AGA appearing for the state and its functionaries vehemently argues that pursuant to direction of learned single judge, an inquiry was undertaken and that the report of the inquiry suggested that the vision impairment certificates were not genuine in as much as the entries as to their issuance were not reflected in the issue register. First off, he draws our attention.
40%.
He draws our attention to the contents of the report, more particularly the conclusive part at the internal page
44.
No, running page it is.
10.
11.
Page 10.
10 and 11. 10 and 11 of the set itself. First.
Next up. 8, 9, 10, 11.
All certificate. Learned counsel, be seated. Kindly be seated. Learned counsel representing the employees vehemently resist the appeal, contending that it is an intra-court appeal and therefore it will have its traditional constraints of its own. First off, he also submits that the learned single judge, having analyzed the expert evidence, namely the inquiry report, has arrived at the findings that are favorable to his clients, and therefore another look at the hands of this court is not desirable. First off, he contends that in any event, merely because the issuance of the certificate has not been reflected in the issue register, one cannot hastily jump to the conclusion that the certificate themselves are fabricated. First, he also draws our attention to the inquiry report, which the learned advocate for the state heavily pressed into service. First, having heard the learned counsel for the parties, having perused the appeal papers, we decline indulgence in the matter for the following reasons. Number one, the selection was of the year 2011. The subject certificates in question were issued anterior to the selection year. They prima facie have the contents which purport to be true and correct. First, the inquiry conducted does not appear to be satisfactory in as much as the authors of the certificates were not confronted with these certificates to have their say over the same. First of all, had it been done, it would have been very easy to ascertain the authenticity of the certificates in question. Next point. The reliance of State Council on the inquiry report in question to us appears to be selective. First off, a certificate of the kind broadly fits into the contours of Section 45 of the Evidence Act 1872. First off, it has been long settled by the decisions of the Privy Council that courts are the experts of experts, and therefore the expert opinion is not conclusive. First off, of course, the expert opinion enjoys presumptive validity to an extent is also true. First off, at pages 21, 22 and 23, of the certificate in question, we find the contents that are favorable to the case of the employee. First off, learned single judge also has weighed the certificate in his own wisdom, accumulated wisdom, and has arrived at the conclusion with which we are broadly agreeable. First off, next paragraph. In the above circumstances, this appeal being devoid of merits is liable to be rejected, and accordingly it is, costs having been made easy. When are you going to implement the order?
Already been subject to writ appeal.
Yes. Which is the judgment. Courts are experts of the experts. Take out and give that judgment over researcher. Yes. And the judgment as to how the certificate should be approached. Yes. See, you start writing that transcripting only after he furnishes those rulings. Otherwise, keep it as it is.
Item 15.
Yes.
Listen, copy and the counter copy is not available with my file, so that I
want some
needs to.
Okay. You want title. 2 weeks at the request.
This case
of the copies.
Yes. No. I have only order copy.
Appeal memo?
No.
You saw the appeal memo?
The matter
then delay of 250 days may be condoned. I will ask.
Delay perhaps there is 200 something.
250 days.
If you come with 400 also,
yes,
will continue.
I concede so that I'll make a prayer in next case. I have 160 days delay.
He will set off that. State appeal is quite brooking a delay.
Yeah, appearing along with this policy.
250 days. First of all, an application supported by affidavit plausibly explains the delay proved and seeks its condonation. First off, learned counsel appearing for the respondents, although initially opposed to the application come up, now agrees with our view that there is plausible explanation for the delay and therefore it is entitled to be condoned. First, next, in the above circumstances, application having been favored, delay is condoned. Okay. Copy, sir.
Maybe short date may be fixed.
After 3 weeks. After 3 weeks. Short date very difficult because calendar is heavily boarded now.
Yes.
Item 17.
17.
There will be 160 days delay.
Your correspondent.
Yes.
Then you have to reciprocate, no?
Yes.
Appeal by the private party is filed with a delay of 168 days in filing 72 days. 172 days. First up, an application supported by the affidavit seeks its condonation. First up, learned counsel appearing for the state opposes the application, contending that delay is long and explanation offered is not plausible. First up, we do not agree with this. Next paragraph. In the above circumstances, application is favored and delay is condoned. Yes.
Item 18.
Yes, sir.
For the respondent, my lord, copy of the writ appeal may be
not given to you. Mr. Panda, give that copy.
Delay is there, delay may be condoned.
18, my lord, a writ of appeal copy may be served upon me.
He will give you appeal, but can you condone the delay?
I will file objection.
You will file objection? Call after 2 weeks at the request of Mr. Panda or the DHEA.
Item 19.
19.
Yeah, my lord. Pursuant to Lordship order dated 1/7/2025, my lord, I have received a copy of the appeal memo. I am appearing before Honorable Single Judge. Lord, only pray, my lord, let it come next week so that I shall file.
3 weeks. 3 weeks. Yes. Call after 3 weeks at the request of.
Mahapatra, you have served copies?
Yes. Have you served copies?
Yes. Okay. But you have not filed your power, or what?
Since I have not filed the power,
please do that.
Yes,
because it's still the noting is there.
Yes.
Power return address cannot be located.
That's why I pray. In the meanwhile, I shall file the.
I'm sorry. Kindly repeat your name.
Vibhuti Bhushan Swai.
Mr. Vibhuti Bhushan Swai, learned counsel, appears on behalf of the respondents. Submits that he has already received copies and may be granted for the time to obtain to file wakalatnama on behalf of the respondents.
Item 20.
20.
I'm at this, my lord.
Yes, my lord. The petitioner, while continuing as a CRCC in 2013, they are relieved in March.
That similar matter you argued, or
yes, I have.
So when it is posted?
20.
So whenever you are having a batch of cases, please try to.
So that one
at
batch
least
can.
My lord.
1st of August.
1st of August is.
October. Do you have copy? The petition copy? You have that appeal number? Appeal number at least.
One.
Okay. You just see that one. We'll.
Not so direct. Not so direct.
Not working in that period.
So no work, no pay. But he says that since I joined, so you are directed to
call for the attendant register of the
same order, but
Teachers.
2759 of 24.
759 now?
24, madam.
24. Please print out the order. Last order. Same order, Mr.
25th.
Same order.
25th.
You are my son.
25th or
1st August.
Don't let us confuse them. So let them simply find out the order and print it. The date will be automatically there.
Same order. As in number they have given. Just right now.
2759, my lord.
Of 2024.
24.
Where we directed production of that
Attendance register.
that one.
Basic document.
Yes.
Okay. Read the bill, yes.
EW.
Item 21.
That's
Mr. Bhanti, please give the list of all the
Item 21, I have entered appearance for the respondent, Your Lordship. They have filed an IA for condemnation of delay. The copy has not been served upon me. The copy of the same has not been served.
How many days delay? 179 days delay, brother. We'll condone delay.
Here is
We'll give them copy
here is
also.
the case, my lord. Why delay?
Similar matter has been posted to 28th of July.
Similar matter.
My lord.
Similar
That is
matter.
writ appeal 2652 of
Here is the
2024.
case. Case is, my lords, there is an application for the employment for
Nursing officer.
nursing officer. While dealing with the application, the Honorable Single Judge has struck down the rule of the
Rule itself is
struck down. And without any pleadings and prayer therein.
no pleadings.
No pleading,
No
no
prayer.
prayer. No prayer. Lordship, in that light, I have to say one judgment.
But already we have
Lordship have heard.
admitted.
Yes, Your Lordship. Similar matter your Lordship have heard and your Lordship has been
Yeah, it's
pleased
a
to
fact,
stay that
it's a
judgment.
fact.
And your Lordship have posted the matter to 28th of July.
Lordship, see that judgment.
We'll condone. We'll condone delay.
Ma'am.
On that day, you judge. You show that judgment also. You share a copy of that judgment.
Lord,
That matter also.
No, Your Lordship.
The 28 you are mentioning. That
My lord. In that matter, I am not appearing.
Anyway, similar matters.
Similar. That matter is similar.
That reference also.
Yes, I will call. Lord, I have filed IF.
Application will allow that.
Ma'am.
How many days?
179.
120 days. Condone. You write draft that order. Same order.
IF formula stay of the
Allowed.
Allowed.
Another identical writ appeal, Your Lordship, I am giving
All this
providing
matter on along with writ appeal.
along with writ appeal that is 2627 of 23, Your Lordship.
2627 of 23.
23. 2023.
20?
2023,
2023.
My lord.
which has been, which is stated to be posted on 28.
Not say. Call it.
The similar matter is 2652. Another matter which has been left out but not listed.
Not yet listed.
Not yet listed. That is 2627 of 23.
No, listed matter is which?
Listed 2652.
2652
of 2024.
2652
My lord.
of 24.
24.
Call this matter along with the 2652 of 2024.
Another identical matter which has not been listed, that is 2627 of 2024.
Along with the writ appeal 2627 of 2020.
My lord.
All.
Item 22.
22, Lordship, I am appearing on behalf of the appellant.
My lord, this restoration application has been filed by the appellant to restore.
It was dismissed.
It was dismissed by the Honorable Court due to
Not yet restored.
No, my lord. No.
Any delay is there.
10 days delay.
10 days delay.
Yes, my lord.
2 applications you have filed now.
Yes, my lord.
2 applications are there by the. Is it petitioner? What is that?
It is petitioner.
By the petitioner.
CMAPL order.
Petitioner. One for condonation of delay in filing the application for restoration of the matter to the board back. First, delay is short and explanation offered is plausible. Therefore, the application for condonation of delay is favored and delay is condoned. Next paragraph. The learned counsel for the petitioner also points out that there is a plausible explanation as to why the what is that you were not present before the court or not complied with the
My lord,
requirement?
this is a transfer brief. The conducting counsel was.
We are asking you why it was dismissed.
Due to non-removal of defects, my lord, and non-appearance of the part.
Both,
my lord.
Both non-appearance and non-removal.
Submits that both the non-appearance of the eventful date and non-compliance of office requirement within the prescribed period are neither intentional nor due to negligence, but for bona fide reasons. First, we agree with this. Next paragraph. In the above circumstances, this application is also favored And the order dismissing the petition dated so and so, order dated so and so, dismissing the petition for non-prosecution is recalled. And as a consequence, petition is restored to the board. All right.
My lord, another prayer, my lord, in IA 261 for dispensing of certified copy of this.
You have produced the copy now?
My lord?
Have you produced other copy?
Yes, my lord. Other defects has been removed.
Certified copy, when did you produce? With the office, because office has to verify that.
Delay, so many things are there. Na?
So
we need time we produce.
Yes, my lord.
Yeah. Office objection to be complied with in 3 weeks, 2 weeks.
2 weeks.
3 weeks.
3 weeks. 3 weeks.
Don't again get dismissed.
No, my lord.
No. 22nd का खोल देना.
In this batch of state appeals, the state has filed appeal challenging the order of the Honorable Single Judge wherein the Honorable...
You have not appeal memo. So Das has already appeared. So.
Last occasion, I will recollect, I have given a judgment, order of the coordinated bench, wherein this order, because base of cases was disposed of, the appeal was dismissed. I have given that order last time. And the Supreme Court has also... Yes, I have given a...
Then nothing survives for this.
May I please, my lord? I am in sub-item 4, your lordship.
Judgments are similar.
The Honorable Supreme Court has also another case, they went directly to the Supreme Court.
Yes, that also is rejected.
Yes, this is the order, man. Kindly have it.
Because when Dr. Mishra gave another judgment.
It is covered, my lord.
Covered.
Same judgment I have given.
So you were giving this to go through?
Yes.
Yes. I have to examine.
The subject matter of all these appeals having common questions of law and facts is squarely covered by a coordinate bench decision of this court in writ appeal number
468 of 2024
between
and 465 of 2024.
Between so and so. Heard and disposed of by a coordinate bench of this court, quite an order dated so and so. First, learned counsel appearing for the respondents points out that identical question is also settled by the apex court in SLP number 9.31 of 2024. And therefore nothing survives for consideration in these appeals. This assertion of learned counsel for the respondent is not disputed by learned state counsel Mr. Banda. First of all, in the above circumstances, and these appeals are dismissed.
How many more writ appeals?
There are another, I will give the numbers, my lord.
Give the number.
I have given the last time.
No,
it is there. Can I person, madam? Yes, sir. These are can be disposed of tomorrow also.
Today list will be by special notice.
Yes. Same batch of
2 p.m. at 2 p.m.
We can call those matters. List them at 2 p.m.
Mr. Panda, you take the list. You collect your files also.
Need not keep matter pending unnecessarily.
For no
that will reflect, the court will be reflected in bad light.
They don't give number.
See number
Photo portrait doji se bahar kar do.
These copies are just to keep the photo and clarify also.
Deeply obliged.
Mr. Mishra, you are appearing in which serial number? 322?
Sub-item 4, your lordship.
72?
Sub-item 4. 3225. 3225.
3222 rather.
3222 23.
Double to their wrong elements.
Vinod Mishra. Mr. 3225 next page. So that's your matter also. Give your
all of them. My name is there now.
My lord, it's there already.
I'm giving.
Only 3223. No one is appearing. Is it so, or it is not mentioned?
It is a matter of distance.
My lord, mine is 3225. 3225, my lord.
There I was conducting.
3225.
I was conducting that case in the writ petition.
Yes.
So you have instructions also.
Instruction, but I could not find the booklet. I was appearing in the writ.
You appear in the writ appeal also, you take notice for that?
Yes, I can have. I have given all the numbers, but I was conducting all the cases. All cases in the
It was his case. It was his case. So he'll give all the numbers. Oblige.
Lordship, 34 Miller's register of this unput requested to take time to reply the
Region file.
Counter rejoinder is ready. We have already there.
No. You have given a rejoinder. I have to reply because he has annexed certain documents for that.
At the request of subject AGA, the time is granted for filing a reply, if any, within 2 weeks. Within 2 weeks.
May I request also, because this is a matter of premature retirement.
Of which year?
Up 2023, of course. Your Lordship have delivered a judgment recently. I have gone through that judgment.
Let us see.
Record may be produced so that Lordship will not further again.
The respondents ready to place before this court the original records. Or even copies of the records. Original record. CD cover.
Ordinarily, you are used to pass.
That's what that is. Call up the 3 weeks.
Item 35.
My lord, the state appeal, my lord.
State appeal. What is it?
I'm ready.
You're ready?
Yes, Malik. I have also prepared.
The delay condonation books have been presented. So that noting has come. Delay already condoned, my lord.
Condoned subject to presentation of the books, na?
Yes, yes.
Have you presented the books, Mr. Panda?
Perhaps. Yes, my lord. Yes, I presented and we have obtained the receipt also. I'm having the receipt.
We'll have this in the 3rd week of August.
Malva, I am ready in this case.
You are ready, but we have to read and come back.
On last occasion, your lordship has said, because when bill condonation of delay.
Next week, lordship.
You allowed condonation of delay with understanding that it would be.
Yes, that's right.
Ready in the matter? Yes, yes, start. Mr. Panda submitted and we agree that the condition subject to which delay was condoned is complied with by presenting the books in question. Yes. What is this matter about? Make a statement first. Shall we pass over?
No, not pass over. This is appointment and age relaxation matter, my lord. The applicant was is aggrieved by the age relaxation given to the SCBC candidate, and we are aggrieved by the order of the learned single judge. Lordship, kindly see the running page 19 of the brief, the writ appeal, running page 19, the internal page 4 of the impugned order, where the contention of the state is at page para 6.
The WPC, just sorry for interruption. WPC OAC is 2695.
WPC. Yes,
there the selection of respondents 6 and 7 have been challenged.
Yes.
You are applying for 6 and 7 or?
No, I am from only.
So where are 6 and 7?
They are not.
They have not appeared. The notice was issued. They have not appeared.
They are not turning up.
Then today we cannot take.
No, not today. On last occasion, they have not appeared.
Correct. But today, because of the bar resolution, we cannot take. Because there is one. And if we do something with this adverse to them, they may challenge it, saying that bar had passed the resolution and still they have taken the matter. They will fix a date.
Well, they have not appeared. They have not appeared.
And Mr. Khunti and Mr. Panda, 6 and 7 are still continuing in service or have been?
Yes, they are continuing because my Lord's Honorable Single Judge order was that without affecting their service.
Without affecting their service?
Yes.
So that prayer is rejected. So then what remains?
Why they should be heard in the matter? They need not be heard in the matter.
Yes, madam. They will not be
Pro forma participant.
Then argue that.
Not pro forma.
No, I'm sorry.
Prayer one is to set aside. Was there in this?
That is not granted.
Not granted.
Not is not granted, and you are not filed appeal on that.
No, madam.
Yes. What is challenged, Mr.
My lord, page 19. 19 of the running page and the internal page 4. May I just place one paragraph? That was our contention before the learned single judge. That the Mr. Balabantara, Lord and government additional government advocate.
Names generally are not pronounced in the court. Lawyers' names.
I'm sorry. I'm sorry. I am.
Mr. Learned AGA.
Yes. Learned AGA. Advocate made his submission bringing on record stand taken in the counter affidavit. It is contended in view of the decision of the Honorable Apex Court in the case of Jitendra Kumar Singh, even though the opposite party number 7 availed the benefit of age relaxation as an SCBC candidate. But since the petitioner as well as the opposite party number 7 secured the same mark, opposite party number 7 being senior in age, he was appointed as against unreserved vacancy. Mr. Balabantara further contended that Mr. AG contended that since opposite party number 6 has secured more than the petitioner, as well as opposite party number 7, he was selected as against the unreserved vacancy, even though he had made his application as a home guard.
Means what? What is the substance of this paragraph?
This paragraph will not. That by this reasoning, my lord, the petitioner cannot be aggrieved, my lord.
7 also. Para 7. Can you make out what is para 7?
Para 7. The next para.
Yes, because that's the court's conclusion.
Having heard learned counsel for the parties and after going through the materials available on record, it is found that the petitioner, while made his application against unreserved vacancy, opposite party number 7 made his application as a reserve category candidate, SCBC category.
It's slow because you will miss it. Because
similarly, opposite party number 6 made his application as against the vacancy meant for home guards, therefore placing reliance on the decision of the Honorable Apex Court in the case of Nirav Kumar Dilip Bhai Makwana, so relied on by this court in its order dated 31/1/2023.
Nirav Kumar facts are not disclosed. This case facts are also not disclosed. So you have to bring on record the mark secured by the last unreserved candidate, mark secured by each of these candidates, and SCBC, home guard reservation. Home guard reservation, I think, is a horizontal reservation, not vertical.
Yes.
So these details, unless you give,
we cannot decide the matter.
Not understand.
Where is the discussion? Where the foundational facts are not stated. Every detail need not be in a petition, but foundational facts which give rise to rights and obligations, right to relief, etc., they have to be stated here. Simply saying that covered by Jitendra Kumar Singh, that makes no sense.
Well, may I clarify?
And please exchange those notes. No,
you give
it is a record.
We have to
that simple table. The last mark by the unreserved candidate. Because the issue is, suppose this SCBC candidate has secured more marks than the general candidate, then he is not to be counted.
No, this
second aspect that whether
this respondent has secured equal mark with me.
I don't know. I am not asking that way. I do not know even. By reading this, I am unable to.
Yes.
I am expressing, as I yesterday said, that my blindness regarding the facts. So that please make a short. And both of you agree on the facts.
Yes, we are agree on the facts. The facts that last man under your category, that of number 7, and he has secured same mark with me. He belongs to SCBC category.
Look at Mr. 8, para 8.
Well,
third line.
With due
disengagement of OP7. So that is a serious consequence for OP7.
Yes.
And submission of OP7 is nowhere there in
paragraphs at all.
In para 8.
However, it is observed that if there is any vacancy, so that vacancy is vacancy. Which vacancy?
Any vacancy under SCBC category, because he cannot be accommodated under your category.
Any mark you are adding SCBC?
Yes, I am married.
So that makes it ocular opacity of some 40% or 50%.
I am married because
Same marks you have secured equal number of.
Yes, it has happened in this case. I and that respondent secured equal number of marks. She was selected on the ground he is elder in age. I challenge selection of two persons that even if he is elder in age, as he does not fulfill the eligibility criteria as provided under the rule for the under UR category, he cannot be considered against UR category.
What Apex Court said in Indra Sahani is, where in a reserved category, if a reserved category candidate scores equal marks with the unreserved category candidate, then he should be preferred.
Yes, but on the basis of merit, even if one belongs to reserved category, he will be treated as honest. Yes, there is no dispute about that.
Correct.
Here, my submission before my lords, that a reserved category candidate who was availed in relaxation, he cannot be treated as a reserved category. Relaxation.
In other words, relaxation of fees cannot be granted.
Yes, relaxation in the eligibility criteria.
That cannot be relaxed at all.
Yes, who was availed relaxation in the eligibility criteria, he cannot be treated as you are.
So then Mr. Kuntia, what fell from my lord is exactly his version. Then how do you read the Indra Sahani? It's yet because they say reservation is lack of merit.
Yes.
You see, the SC or ST candidate. No, please, why you are apologetic? Then we will not stop discussing also.
No, because I intervene.
No. Because suppose SC candidate, he will be getting a age relaxation. ST candidate will also, but they top the list.
Yes.
So how you will treat them?
So far as SC and ST are concerned, I'm conscious about that.
Gradually.
So far as SCBC is concerned, yes, madam. Why I am saying, so far as SCBC is concerned, there is no relaxation for SCBC.
Mm-hmm.
Yes.
When you say no relaxation, social and educational backward classes, that subsequent decision of
backward classes.
What is that decision?
Asking this question.
SCBC reservation has been upheld in so many decisions.
No, in SCBC reservation, your lordship has set aside that act.
Act itself is.
Yes.
No, that is you see that's a daring decision. That act, that decision which is pending in Supreme Court, challenged in Supreme Court, because SCBC reservation has been upheld in Indra Sahani. Please appreciate that.
Yes.
And if you don't allow the court to complete, then I cannot complete.
No, normally, lordship.
So after Indra Sahani declares 27% reservation for SCBC, OBC or SCBC, can any High Court set aside without considering Indra Sahani?
Considering the Indra Sahani case, that the act was declared alternate, may I give that I have prepared a compilation.
No. You see that that judgment because I was the counsel there.
Yes,
so that judgment not considering SCBC reservation. Indra Sahani says upheld. According to you, Indra Sahani doesn't uphold SCBC reservation.
No, that reservation cannot exceed 50%. That Indra Sahani says.
No, please.
There are many principles. 17 principles have been laid down in Indra Sahani. One of the principles says ordinary ceiling limit is 50%.
Yes.
So where this High Court has set aside SCBC reservation, the state's affidavit and notification confining the reservation to 27% is also there. They have considered that. No, you have not checked it.
Yes, I have checked. I have prepared a compilation.
No, not compilation. You find out that particular paragraph where they have set aside, and they have also considered the affidavit is filed. Affidavit is on record.
Yes, ma'am. That judgment I have that judgment, and also after that judgment, government has passed a resolution.
No.
Yes.
No, Mr. Kuntia, please kindly don't argue in that way. Please listen, sir.
Yes.
We may be wrong also.
Yes.
This is a war of
this
is a discussion.
Yes.
So that it becomes easy. Otherwise, suppose we keep quite like a sphinx.
Yes, miss.
How will you know what is lurking in the mind of the judge? At least we are giving piece of our mind to you, so that you can answer and hearing becomes meaningful.
Yes.
Therefore, you should never get offended when judges put questions. When lawyers put questions to us, we also should not get offended. We should just treat them. This, after all, the marketplace of ideas.
That 27% reservation is a subject matter of challenge.
So many stays into it. But it is struck down. It is struck down. So she has been
But whether after it has been appealed by the Supreme Court in Indra.
What is the status of
that is pending?
No stay or that?
No stay.
It is admitted.
It is because of the after the judgment, government come with a resolution. Only in respect of age, there is no
concession.
No concession. Only 11.25% reservation was extended in favor of ACBC.
In other words, for the limited purpose, he will be treated as a general merit candidate. So far as eligibility conditions are concerned, he is bound to follow those conditions.
Yes. And the reservation 11 to the extent of 11.25%.
High Court division bench, can it override the 24?
The executive power also that can be done.
Another judgment that the reservation can be provided by circular.
Circulars also.
So, Mr. Khuntia, because you are so emphatically arguing, which paragraph of the judgment where this High Court set aside reservation for SCBC has taken note of Indrasan?
Indrasan, that.
Just look at the judgment, then find out.
Look into. I do not know the judgment of this court. My reading of Indrasan.
And the other difficulty is that that judgment takes note of the fact that the total reservation is confined to 50%.
Yes, that is 50%. There is no bar. 50% reservation is there.
No. So, setting aside an entire provision of SCBC as per Constitution, you see, and 14.3, 14, 16 are not also not taken note of. Because Indrasani opposed that this is not an exception. This is a manifestation of equality.
Affirmative action.
Affirmative action, 16.4.
I relied upon the resolution of the government, where the government said that they will be extended with 11.25%. And second, I am relying that recruitment rule. On two grounds, I have challenged the selection of two private respondents. First ground, that SCBC candidate who has able relaxation, he cannot be treated as you are. Second ground.
No, one second. How you are aggrieved by this order?
Yes.
The appointments are saved. How you are aggrieved by this order?
They also do not know the facts. That's the problem.
Judgment is not. It is not stating the facts. Judgments also. Anyway, how you are aggrieved by this order? The appointments which has laid a challenge to, they are upheld only. Those appointments are not nullified. Then how you are aggrieved by this order? It may be a wrong order.
State policy is being affected.
We will say this judgment is confined to the parties to the proceedings.
Yes.
That may not create a precedent.
Making error like not looking at
it is
because those two persons have already given you the walkover by not turning before the court.
Right.
Have it on 22nd, come out with.
Or today, can you give those details of the candidates? Which category?
They're not possible.
Mr. Khuntia, can you give that chart and exchange it with?
Yes.
But you have also not filed appeal against this order.
No.
You are happy with
He's
this
happy.
order?
Because that's how he's not. You sought appointment.
Yes, that's my entire grievance. I sought for an appointment because I am an unemployed. So when the honorable
So you are the last in the unreserved category?
Yes, because he got appointment, I could not get.
Oh, you are in the which category?
Under you are
What relief is granted to you in this petition?
that happened to give me appointment.
Which is that?
Yes.
Patna, can you give that compilation?
Yes, please.
Put an inch.
As against your category, with two disengagement of OP number 7. However, that is another variance.
Paragraph 8, madam.
Then the direction in your case.
Stop down in your compilation.
No, in that compilation, I have not but that judgment is with me.
Do you have copy?
Yes, ma'am.
Just share that copy with us also.
In this
Copy or reference or
that I am giving that copy, my lord. So most of our
Possibly remember that case. That's why incidentally.
yes, you were there and CP Rao.
Yes, my lord was one. I was
listed.
And my lord
question was that that Act 2009 Act, that SCVC Act, the sole ground was that the quantifiable data has not been collected
before making the act.
Before making the provisions of this.
So almost on par with
I was rightly said, so far that Indra Sahani 93 Supreme Court is concerned, that paragraph, that backward process, that in fact terms has not been taken into consideration.
That data was not collected.
Indra Sahani says that for further available data, it is 27%. So give 27%. In Odisha, SC/ST reservation is 39%. Here, ST is 27. It is 11 is 12 is SC. So you can maximum go 19. But all the issue is regarding whether Odisha can give 27%.
Yes.
But now the court comes up with a proposition, no reservation can be given. That's the problem.
But what they have done after that judgment was passed declaring ultra virus, they have made it 11.25.
Yes, that I have
given. So 11.25 was there already.
Already that was
already there.
Yes.
The background is that this is, you see, highly sensitive matter.
It's very, very sensitive. Some promotion.
PP Rao was
in Odisha from the inception 27%.
No, now the problem is that
in Odisha.
No, one paragraph I just I glanced at when you
initially it was 11.25.
It was 11.25. That was increased to 27%. That was the subject matter. But that increase was by the legislation.
And more than 50% has now been approved by Supreme Court. In case of
Madras case, also remember that case was
Parasar or
Tamil Nadu.
Tamil Nadu.
The second case, they have said that.
So it's a very serious matter so far the Odisha state is concerned. Every day we are facing that. In promotion matter, that Prabhakar Malik's case.
That's what we said. That's requires deeper consideration because you say that policy considerations are involved. In this individual case, what we will do is another thing. If policy considerations are involved, then deeper examination is required because he also raised another point, which was not considered by Indra Sahni also. So far as the initial eligibility condition is concerned, whether that can be relaxed or not is the first question. It's not no other discussion. It's something. Just
copy मत दे दो कॉपी करके अपना
Thank you. Let us see, it requires consideration. The point which you have raised is of serious consequence. That does not appear to have been considered in Indra Sahni. Indra Sahni was given in a very, that judgment was given in a very socio-legal turmoil in the country. Many aspects were there. So, let us see, we'll also read Indra Sahni again. Long ago I read, I don't remember that one. There's very, and Indra Sahni itself, there is a book. Yes. What Indra Sahni decided. There is such a book by Bora brothers.
Yes.
Path-breaking judgment that.
Yes, true. We'll have this, brother, we'll also need some time to go through Indra Sahni notes. Now it is very easy if we put it to ChatGPT and ask what Indra Sahni says. Whole entire gist will be given to us. But we will not go by that one. We'll read the judgment also.
So for the next part is concerned, next part, I have challenged on 2 grounds. Second part is concerned, a home guard category, we selected he to fit, because it is a horizontal reservation, we selected he to fit it.
Since he may not rake up the issue of, his constitutional validity and all that, only that your appointment as fell from
that
will not be,
I am not
only impacted.
Only to my appointment because I am out of my employment. That's why
you want your goat back. That's all.
Yes,
but there are other aspects which the state is raising. Let us see. Let us see what can be done. Call this matter on 29, no, on 7th of August. 7th or 8th of August? Yes. Okay. It's but very complex question which I have not seen any decision like that, nor contrary decision.
One decision I have also given, one decision is there.
It decides that issue.
Yes, this one
we'll go through it.
And it have a copy for
But foundational facts should have been stated in the judgment itself. If we read the judgment, we need not travel outside to find out what facts are necessary. No more facts are necessary.
I will also prepare a short note.
What note you prepare?
Canvassing the foundation.
Take out that also.
Item 30,
33 million or three identical, three appeals have involving identical questions.
What is the question?
One predicament is that a lordship awarded cost in a one appeal, which we are yet to deposit. We are in the process because of today's bond, my lord. We could not deposit it. We will deposit and
then we will take up. How much cost we have awarded?
4,600 rupees.
Even that is not paid.
No, that could not be. Shorter time was granted, my lord. It was
whether government needs to print that money from treasury, what check will do? Anyways, they'll grant this, call this matter.
That man is suffering, that is my
yes,
that is why my lord is fixing shorter dates.
Shorter date.
One out of three.
Same.
So one candidate we awarded cost.
Yes.
Not for rest. I am the author. I am the author of the order that day.
Common judgment. Only one judgment.
In one judgment.
Yes.
With regard to regulation of their service. Kindly fixes out date, sir.
Next week, any date, next week.
Yes.
On 25th, all right?
My lord.
Call on 25th. By that time, we should comply with that.
Definitely.
Yes.
By Monday, we will comply.
Yes.
Item 38.
My lords, I'm appearing in the virtual mode, my lords. I'm for the respondent bank, my lords. And my learned friend, who is the appellant, had called me up in the morning that he doesn't have a virtual mode to link in. So if a short date can be given.
I am appearing. I pray for time.
You also want time? Call in the third week of August 2025 as requested at the bar. Okay.
Item 39.
39, two private appeals and one state appeal. Wherein, my lord, considering the gravity of the appeal, my lord, the Lord AG is supposed to submit before a lordship.
Whether aided institution or not.
Yes.
No, aided institution are eligible for the UGC guidelines.
Eligibility for aid. That is also covered.
There is a minimum qualification of appointment of lecturers in non-government aided college, whether as per the UGC guidelines or not. Here is the appointment is the postgraduate with 55% mark. But UGC guidelines says in degree colleges, postgraduate with NET or PhD.
Whether that extends to these people or not is the question.
Yes,
whether that applies to them or not is the question.
Yes, Mr.
You mean to say only colleges which are receiving UGC grant, that alone are governed by the UGC regulations. Rest of them are not governed by the UGC regulations. Is it your case?
This is the argument of the state. But my argument is
that is our plea.
Your argument.
But my argument is that once the state is adopted the UGC regulation.
So suppose you see it is not, if it is a level playing field, you are not thinking about the other part. State has reduced. Suppose your argument is that state has reduced the eligibility criteria less than the prescribed by UGC.
Yes,
so you are more qualified.
Yes, madam.
So there is level playing field for you.
No, what is the minimum?
You want that I have secured 60%. I'm the rough example. They have secured 59%. They should not be allowed to compete.
No, my lord, that is not issue.
Then there is certification required also. If you allow all of you compete, because it is not based on your qualification or degree or percentage.
No, my lord.
The UGC regulation says.
UGC regulation says for appointment of teachers in colleges, degree colleges, it should be postgraduate with NET or PhD.
With NET or
PhD.
Then it is national
eligibility test in concerned subject.
In concerned subject, of course. Or PhD
in concerned subject.
But in this, there is no such.
Here is a case,
yes.
So far the state of Orissa is concerned. In fact, the aided colleges are concerned. There are different type of aided colleges. These are all block grant colleges. Block grant colleges means a substantial sum total of the amount is being given towards the salary. A part of that, the rest part is to be borne out by the management. Now the whole question is the advertisement which was made, that is in terms of the state rule. That means the minimum requirement 55%.
Which is less than UGC.
It is less than. UGC has a different type of regulation so far the qualification is concerned. Whether now the advertisement has been quashed, one advertisement was quashed, the other advertisement because they have got the appointment that was allowed. That was quashed on the ground that UGC regulation has not been followed. So now the question for consideration is, if the state has followed the UGC's regulation in respect of a particular category of institution, certainly the UGC's whatever guideline or regulation is applicable. And so, but once the UGC regulation is applicable, then they are entitled to get the UGC scale of pay. They are also required to satisfy the requirements of educational qualification. So these are matters to be considered by your lordship vis-a-vis the state's laws and the
central law.
Yes. If there is a conflict, definitely central law will prevail. If there is no conflict and there cannot be reconciliation, there can be reconciliation, which is being followed in the state of Orissa for a long time, that your lordship will decide.
254, yes, 4, 3 or 4.
Yes.
No, 254 also it will not travel to because there is no separate legislation at all. No legislation.
No legislation. Means there is no chance, one can argue, there is no chance this
conflict. What Apex Court said in 2011 was, in addition to UGC requirement, state can prescribe additional.
Yes. Higher qualification can be prescribed. That is
but whether state can prescribe less than what UGC has.
Yes, that is one point.
That is the question.
That's it. Provided state has a right also, as they have taken the plea, that they have said that the UGC is applicable in respect of this type of institutions.
And for others, it is not applicable. Let us see the UGC regulations.
That is what the core issue.
Let us see the UGC regulations.
Yes.
How they say.
That has been clarified in the single judge.
Saying that they should be followed.
Yes, that's part relying on the various judgments. The lordships, there is several judgment has been in favor of the UGC guideline.
That is there.
And the single judge has held that is applicable. And recently, not 2 to 4 days.
You appear for UGC.
2 to 4 days back, Punjab Supreme Court has held that the UGC regulation is bound to be applicable in each states because of the standard maintained the standard.
That Mr. Rautre concedes.
Yes.
That is his opening argument.
Yes.
That is definitely applicable.
1992.
But can there be support? Then Mr. Sarpati.
Yes.
Let us take a statistical aspect. Let it be relevant also. How many candidates clear NET to be eligible to get employment?
That is not. That is quite.
Not quite. Suppose you have thousands seats of lecturers. You have 2,000 NET qualified candidates. Fair enough. You have 1,000 lecturers, 100 NET qualified candidates.
Right.
They are not made ineligible as far as state colleges are concerned. That I was asking him. He could not get it.
No.
Is this prescription makes other NET candidates ineligible? If the answer is yes, then it has to be struck down. It gives a level playing field for all. Suppose the second category could be that suppose there are 2,000 NET candidates and 1,000 vacancies as far as lecturers are concerned. Then there is a case also. But NET eligibility, like it was earlier not there, MPhil was there, MPhil has been able. It is also kind of it's a kind of a journey for a person who is studying. PhD is awarded in 10 years at times. That's my what I have seen.
Yes.
I can vouch for that. And I have seen it takes 10 years for a research paper to be completed, presented, and all these things. So suppose we make it 10 PhD for teaching. Then where are those teachers having PhD and NET?
But if there is available,
it's not availability. The person who is having PhD and NET qualification, he is anyhow entitled.
Correct.
If your case is that state government regulation makes them ineligible.
No, that is not there. Nobody's case. In fact, learned single judge says they are applicable.
They are applicable. UGC is applicable.
Whether UGC is applicable or not.
Applicable, then sir, these other candidates go out of the application.
That is exactly.
Suppose if they do not have qualification.
That is what my lord justice how.
Sir, they are having they are postgraduates. They are postgraduates 55%. Whether they will clear NET or PhD, That's the question.
No, because of apex court, there are at least half a dozen judgments of the apex court. I may not be able to name
Yes,
them.
So far, the state of Odisha is.
There is one book, Arul Selvam, Law of Education Code. He has given all sets of the judgments. Arul Selvam, a Madras.
Mandir Singh and others. Relying on the.
Mandir Singh. Yes, correct.
So, Mr. Satpathy, have you examined the case law on this?
Yes, no, that has been referred by the
What has been referred?
That has been referred that UGC's guideline is applicable because this
UGC guideline applicabilities, they are not questioning also.
No, they are in 1992.
They are questioning that by exclusively allowing UGC NET qualified candidates, prior to these candidates, there are law lecturers also?
Yes.
Then
we'll start the 1992.
I think Minor Justice Saul rightly put that question. Suppose there are 8,000 lecturers are required in these college. And so far the NET qualified candidates are concerned, or PhD candidates are concerned.
500.
This is the problem.
Suppose we need about 100 pilots. But pilot education is completed only by 25. You mean to say 75 should be appointed because they
Let me tell you frankly. So please listen and you can understand. I may be having more data than you. Please understand that. Most of the medical courses in Odisha many of them are not recognized by IMC. So they cannot get employed in other outside state.
That will happen.
But assistant professor and they're getting employed here. So basic education at times doesn't satisfy the IMC. Even DN. And it happens in all states. I know about Maharashtra. Suppose somebody passes Maharashtra from a particular college, I will not name it. But it's very famous. It's not that it's in the rank of KEM or those colleges. So it happens. Same with pharmacy and nurses. Because you are having colleges where they will be getting employed in Odisha. So that is how this has created a situation where at times the central law or the central agency is not.
So you also keep it to some, because we're going to let him address. We'll supplement. I also got some judgment also.
That Mandira judgment you give.
Yes,
I just put.
Reference.
Have you prepared what Mandira says?
No, I have not, because in my seniors, because they've taken time, so not.
The citation. Citation.
Has not yet been.
Not yet been.
No, there are apps downloaded from the Supreme Court site.
July. Just look into Mr. Panda. This is the latest. Even the ink has not dried. Just look.
I will download and
I have considered many judgments also in this one.
Yes. You can take that photograph also. Keep it.
Share one copy.
Straight away take the print. It is neutral citation is there.
If some citation is given, we will know the editor's view of the that way.
Well, let's
Yes. Lordship,
Passover.
No.
It is 2 p.m. It's at 2 p.m.
2 p.m. my lord.
Personal appearance, today.
Personal
You want personal?
Yes, my lord. One person.
So today there is a resolution, no adverse orders.
Yes, my
It's
lord.
better if you come, your senior will appear.
Yes, my lord. My senior will be appear, my lord.
Some date will give
Some
you.
date.
Short date may be given, my lord.
Hot date. 30th July 2025.
Yes, my lord. Obliged.
Item 44.
40? So that's in all these applications you are from the respondent.
Yes, ma'am. So boy, वकील तुम्हारे देश को आसी पर लगा. Again? Yes.
Your associate.
Yes.
Mr. Panda, have you gone through this? The same
Yes,
order will
same.
that dictated.
Item 32 and 36.
नहीं 36 टा होगा ना. 36 टा होगा सर regulation.
They are over.
Yes, the 36 is 32.
36
It is identical to
Same order we are.
mile way.
32.
Same to 32.
Yes, yes.
32.
Mile.
And any other matter left?
Right. So as they told Shobra office.
Not possible.
Right. So I will give you another memo, my lord.
Memo. Give this there so that they will
It can come.
It's there.
Normal
Mr.
course.
Panda,
Yes,
that
normal
he can
course.
also get his bag.
By sometime in next week. Well,
In these matters, note one line you have to add, apart from what my lord has dictated, that the matters are taken up on being mentioned and being specially listed as they are similar, they are identical and similar to data pin number 2854 of 2023, listed today at serial number 32 and disclosed of by judgment rendered today. This line has to be added. Last in that.
Grateful.